Good afternoon. I'm Tamiko Brown-Nagin, and it's my pleasure to moderate this panel along with my colleague Kenneth Mack on the life and legacy of Justice Thurgood Marshall. Marshall is one of our country's great lawyer jurists. As Director Counsel and Chief Litigator for the NAACP Legal Defense Fund, he argued dozens of cases before the U.S. Supreme Court, winning 29 of them, and in the process, yielding landmark precedents barring discrimination in housing, voting, and education. Most famously, Marshall prevailed in Brown v. Board of Education, the 1954 case outlawing segregation in schools, a precedent that is widely considered one of the great cases in American constitutional law. His career on the bench began in 1961 when President Johnson appointed him to the Second Circuit U.S. Court of Appeals. Then, in 1965, President Johnson appointed Marshall Solicitor General, making him the first African American to hold that office. Finally, in 1967, Marshall won confirmation to the U.S. Supreme Court, making him the first African American to hold that office. And on the court, as you'll hear our panelists explained, Marshall distinguished himself in a wide variety of areas, including cases on the death penalty, education, and poverty, often as a dissenter. Now, we've established a panel in connection with the release of a new film, aptly titled Thurgood, that premieres tonight at 7 p.m. at Assembly Row. The film was directed by a Harvard College graduate, Reginald Hudlin, and you're cordially invited to attend. Our panel today features several distinguished Harvard Law School faculty who had the honor of clerking for Justice Marshall. They are, briefly, Professor Mark Tushnet and Martha Minow, both experts in constitutional law. Professor Tushnet also is a biographer of Marshall. Professor Terry Fisher, an intellectual property expert. Professor Carol Steiker, a criminal justice expert. And Professor Randall Kennedy, an expert on race and the law. And now, for our discussion, I'll turn to my colleague, Professor Mack.
Yeah, the format today is that Professor Brown-Nagin and I are going to ask questions which some, not even necessarily all of the panelists, can answer as they wish. And we're probably going to ask alternative questions, and I don't know, do you think we might have time for a student question? Or?
I hope so.
Yeah, so we hope to have time for an audience question or two at the end. So let me just jump in. First question. Today, some of you, hopefully most of you, are going to see the movie about Marshall. Marshall's big in popular culture now. There's the movie. There was a one-man play with Lawrence Fishburne that played and was actually shown on HBO. There's a Pulitzer Prize-winning book, Devil in the Grove. There's another book by Will Haygood about Marshall's confirmation process. All this stuff has sort of happened in the last 5 years. So lots of people are interested in Marshall. Although we kind of look at Marshall's scholarship, well, that's sort of a little bit of a different thing. The scholarship on Marshall, or at least broadly speaking, often argues that a lot of his work either didn't matter or was counterproductive or matters much less than we might imagine. I mean, two of my colleagues on the Harvard Law School faculty, Charles Ogletree and Michael Klarman, both published books, in effect, saying that Brown matters much less than we imagine it does. And Brown, of course, was Marshall's most visible accomplishment. Lots of people in the community of professional historians have disparaged the NAACP and its school desegregation litigation as an elite project that was not connected to the ordinary civil rights movement. So my really just open-ended and provocative question to as many of the panelists who want to answer it is, does Marshall matter? Or does Marshall's career before he became a Supreme Court justice matter? And if so, how? Anybody want to take that on?
So I'm ready. So you have to answer this sort of question with historical sensitivity. So, does it matter now? Well, in some sense, yes, because he is, for us, this cultural figure. Did it matter when he was doing the litigation that he was doing? I think the answer to that is yes, he was a major figure in the African-American community. There are letters saying when he came to town to do a trial, it was as if Jesus Christ came to town. People flocked out to see him. There's a case in Oklahoma where he was defending a capital defendant, and the kids from the elementary school were taken to the courtroom to see him doing it, to see him defending. And the very fact that there was a black man doing a criminal defense and standing up to the state mattered to those kids. Now, a case called Hollins in Oklahoma, what he got, this is actually part of relevant to the film, what he got out of the case was a life sentence for a clearly innocent defendant rather than a death penalty. So, did it matter? Well, yeah, it mattered to Hollins. Did it lead to Hollins, not being convicted? No.
Yes, it mattered tremendously. So just to take up on Mark's point about what Marshall meant in the black community, I grew up with the name Thurgood Marshall as part of the soundtrack of my life. I must have heard Thurgood Marshall's name mentioned countless times as a youngster. He was Mr. Civil Rights, and I clearly remember my father talking many times about watching Thurgood Marshall argue a case, Columbia, South Carolina, 1948, Rice versus Elmore, one of the last of the white primary cases. And the big deal, my dad was a post office worker. He didn't think much about the legal doctrine involved, the state action doctrine involved, but what he remembered was that the judges and the opposing lawyers called Thurgood Marshall Mr. Marshall. And that was a big deal given the etiquette of the Jim Crow South when black men were not called Mr. So did it matter? Yeah, he mattered. Did Brown versus Board of Education matter? I must say this is a debate in academia that, as far as I'm concerned, gives academia a bad name. Of course, Brown versus Board of Education mattered. On May 16th, 1954, it was perfectly legitimate in my home state of South Carolina for the state to openly and unapologetically separate people in schooling and every other thing on racial grounds. It was part of the state constitution. There was no two ways about it. It was openly done. Supreme Court decides on May 17th, 1954, that in Brown versus Board of Education and Bowling versus Sharp, that this is no longer permissible, at least with respect to secondary and primary schools. And so it's no longer legitimate for that to be done. Does it continue? Yes, it continues, but it is illegitimate. And people have to start lying and doing all sorts of things to cover their tracks. And furthermore, Brown versus Board of Education didn't just apply to schooling. The ramifications applied to everything imaginable. Buses, cemeteries, restaurants, you name it. So obviously people have made too much. They've overclaimed with respect to Brown versus Board of Education. Of course, when any time you overclaim, people come and sort of want to prick the balloon. But did Marshall's handiwork matter and matter dramatically in American life? You betcha. And all you need to do is look around this room to get a little hint of that.
Can I just say one follow-up? When you ask a question like, does some historical event, did it matter? I think a good way of answering that question is actually through art. We're going to all see this film tonight. There are a lot of movies, books, television shows that imagine counterfactually some alternative universe. So maybe you guys know the film Sliding Doors with Gwyneth Paltrow about a young woman and how her life changes whether she makes a subway car or not. Or there's one of my favorite books, Michael Chabon's The Yiddish Policemen's Union, which imagines Israel being established in Alaska rather than the Middle East. Or, all right, you're all like looking at me blankly. Maybe like The Man in the High Castle. Like, okay, now I'm seeing some nods, right? That's a current TV show about what if the Nazis had won World War II. And I just invite you to imagine the screenplay for the movie if Thurgood Marshall hadn't litigated those cases and we hadn't had Brown versus Board of Education and all the things that Randy talked about. I think it's a good way of answering your question pretty definitively.
Wonderful. Thank you, Carol, Randy, and Mark. Let me pick up on the comment about Marshall being such a great leader and compelling figure in American history, and particularly in the African American community, by asking you to comment on what Marshall was like as a person. What was his personality like? What was it like to work for Marshall?
I'm not going to take this one first.
So I'll slide in a little bit on the last question, too. Marshall was gregarious. He was the best storyteller I have ever encountered. He played every role in the story. If there was a snake in the story, he'd be the snake. He had voices, and he was hilarious. He was off color. And that was such an asset when he was at the NAACP, because he would roll into town where people were literally at risk of being lynched if they showed up at a meeting where the NAACP was hosting it. And he made people feel like this was a project they could be part of and they wanted to be. And he, therefore, was the link between massive strategic thinking and actually helping people navigate the very, very challenging time of being part of the civil rights movement, the strategy in the courts, obviously a different strategy outside the courts. So what was it like to work for him? Well, he would tell stories, and sometimes it'd be irritating because you're trying to get your work done. And now I wish I had just stopped and written down all the stories because they were fabulous. He would give nicknames to all of us, and they were mostly not complimentary. And Knucklehead was one of the big nicknames. Justice Souter calls me Knucklehead to this day. I think he thinks it's my name, but he said he knows that that was a term of endearment from Justice Marshall. Justice Marshall also talked in great detail about his life and about his work, not just in the famous cases, but in the not famous cases, in criminal justice cases, in abortion cases. I don't think there's ever been a member of the Supreme Court who had as wide and deep a law practice before or since Justice Marshall, and he would share that. And he also watched soap operas, and he also was part of pop culture. He loved to gamble, and his life was a gamble in many, many ways. He was also tough. He would reject drafts and memos. I ended up teaching civil procedure because of his rigor in civil procedure. I came to him and said, this case is so compelling, and yes, I know the plaintiff filed it a day after the statute of limitations, but it's so important. He got so worked up. He said, those rules are there for us to use. If we bend them, they won't be there when we need them. And that changed my professional career. I now have a case book on civil procedure. I teach it. But nonetheless, his faith in the rule of law and the legal system was profound, even though he also wrote the most searing critique of the bicentennial of the American Constitution that I read, in which he said we shouldn't be celebrating because look at where we are. Look at the failures. Look at the failures of the framers and look at the failures of where we are. So not at all naive, but absolutely someone who modeled for the world that it's possible to use reason and courts to tear down oppression. Probably had more success on issues not racial. While I agree with Randy Kennedy entirely, it's hard for anyone in this room who's not older than 62, which I am, the year that Brown versus Board of Education was decided, to remember a world in which there were not just drinking fountains separated, there were rules that forbade people from marrying, from playing cards together, from trying on clothes in a store, just based on race. Hard to imagine that. That was America. And he tore that down. Are schools better for kids of color in this country? Not so much. And here, probably his legacy is greater as showing a model that's been copied by Ruth Bader Ginsburg on gender equality, by people dealing with disability rights, by people dealing with the rights of Native Americans and Native Hawaiians, and people around the world, actually. So the technology of using strategic litigation to tear down oppression, that's what he pioneered, and that remains something that he was, I think, proud of.
Thank you, Martha. Others want to jump in?
I agree with Martha's characterization, but want to amplify a few dimensions. In particular, the toughness. He was a formidable person in all respects, including in personal contact. He was big, gruff, and impatient with pretense or any undue familiarity. So when, now come back to personal level, we began working for him, he was a little scary. And you didn't early venture much by way of familiarity. A couple of anecdotes along this line. First of all, a bit of context. It's not an accident that there are 5 of us here. There are actually 9 members of the Harvard Law School faculty who worked for Justice Marshall, which is much more than any other justice in American history. And I don't think that's because he turned us to an academic life. He actually had a lot of affection for Harvard, but he didn't have much affection for academics in general. It's rather had to do, I think, with people he picked. And trying to figure out how that came to pass is a little puzzling to me. But anyway, our year, the year I was working for him, which was 1983 to 1984, was the extreme version of this. And there are 3 members of the faculty, Randy, Howell Jackson, and I, along with the 4th person, Gay Gelhorn, worked for him that year. So Howell, Randy, and I, and Gay would gather in the outer room where we talked about cases. And we would very tentatively make our suggestions. If we ever got a little bit too forthright, he would point to the wall and he'd say, I don't see your name up there signed by the President of the United States. So he kept us in check, but slowly through the year we began to be a little bit more teasing. And I remember one moment, it was in late August, so we'd been there for a couple of months. This was in 1983. There was a march on Washington, a commemoration of the '63 march. And there was some controversy surrounding it, and it was a fairly big deal, and we talked about it briefly in the conference room. And I said something like, yeah, we're going to march tomorrow, and we're going to carry a sign that says Clerks of Justice Marshall. And he said, yeah, and you're going to be out of a job. So this was just a little bit of banter, but also lurking here was a principle. It's the other side of the issue that Martha was emphasizing, to some extent Mark, which is he had much more faith in advancing the cause of civil rights through law than he did through activism. He respected Martin Luther King. He didn't respect all activists, but he respected Martin Luther King a lot. But he was not an unqualified enthusiast about protest as a mechanism for social advancement. So one more anecdote along this lines, following up on the general question, what was he like as a person, still on toughness as a theme. My older daughter was 3 when I was working for him. And one day I brought her into the office, and I took her in, and he was kind enough to invite us into the inner office, which was different from the outer office by a lot. And one of the reasons it was different, it was there a lot of memorabilia about his extraordinary life. One of the things there was a lion's skin, a full lion's skin, including the head. And Jessie, my daughter, looked around. And this was a little scary, but he offered to have her sit in his lap. And she did. She sat on his knee, but definitely with the eyes wide open. This is not a comfortable place to be. She remembers it to this day. And ever since then, not ever since then, for the next couple of years, she differentiated judges by size. Now, this related to the fact that the Court of Appeals judge I clerked for was Harry Edwards, who's also black. So Jessie had the idea, which she inferred, was judges in the United States are black. And the way you differentiate them is there's the little judge, that's Harry Edwards, and the big judge.
Very nice.
I have to do 2 things. One, just how we got our jobs. I got my job because this is actually relevant to the judge. Thinking about this, I got my job because the father of the judge I clerked for in Detroit was, as Marshall put it, the only white lawyer in Texas who was willing to sit at counsel table with Marshall. Okay. Now, on the, I want to do a story that Marshall told. I can't tell it in any way, the way that he would. But it does indicate something about both his storytelling and his life and the kind of person he was. In 1945, he was trying a case in Tennessee. And it was being tried in a town where he and the other black lawyers couldn't stay overnight. So they drove out of town every night to go back to, I think it was Nashville. But one night he was, I think the only way to put this is he narrowly escaped being lynched. There was a lynch crowd that gathered and was pursuing him. He managed, with the aid of his other lawyers in the team, to prevent the lynching by saying, okay, the pretext for this is that I'm drunk and driving, so let's go into town and we'll have a judge decide whether I'm drunk. And they went into town and brought him before a judge. He, as he tells the story, I should say this story is true. There's documentary evidence about it the day after it happened. He breathed in the face of the judge, didn't have breathalyzers then. The judge said, this man isn't drunk, he hasn't had a drink all day. And so the judge released him and they left town. And Marshall says, it's actually in the letter the next day, I wasn't drunk then, but let me tell you, an hour later. So now, get that, this is a guy who has just escaped being lynched. And he's writing a letter the next day, in some sense, making a joke about it. It's quite extraordinary.
I went for my job interview and had the kind of cold where no sound comes out of your mouth. I had no voice and I was dripping. I went with my tissue. I called the clerks and said, could I postpone it? Long pause. You don't postpone a meeting with Justice Marshall. I show in. I'm croaking. I'm terrible. He says, My daddy has a cure for what you had. You take quinine and whiskey, and you leave out the quinine.
Just on the experience of clerking for him, the year that I clerked was an unusual year because there was a vacancy on the court. Justice Powell had just retired, and President Reagan was getting to fill this vacancy, and his first appointment to this vacancy was a D.C. Court of Appeals judge named Robert Bork. And this was, the first super highly contested Supreme Court appointment. It was televised. It was riveting television. And Justice Marshall had the TV on for the entire confirmation hearings, and we would, cycle in and out of his office and watch the confirmation hearings with him, which he ran. He had a running commentary on the confirmation hearings, and I'll just tell you one. It was a very famous person was testifying at this hearing, and for some reason, all four of us were in there, I think, for this testimony. And this is a role he often did with the clerks, we were the straight men. And he would say, he's very smart, but you know what? And we don't say, what? He said, he's not as smart as he thinks he is. You know why? We're like, why? He says, because ain't nobody as smart as he thinks he is. So that was a Marshall thing, and it was kind of ironic that and then, Bork, as you know, did not get to be a Supreme Court justice. In fact, his name has become a verb. To be defeated in this way is to be borked. The next appointee was actually a Harvard law professor, Douglas Ginsburg, who was also an appellate court judge, who, as people say, his nomination went up in smoke when there were allegations that he had smoked pot with students while he was a Harvard law professor. And the third try was a charm, and Justice Anthony Kennedy finally took that seat midway through the year. But we were watching all of this with Justice Marshall, and one of my co-clerks is now the only former Marshall clerk to sit on the Supreme Court, which is Elena Kagan. So I wonder how she thinks back to watching those Bork hearings with Justice Marshall. I'm sure she must have thought of that as she went through her own confirmation process.
I had some really sort of profound question about lawyering, but this is so good that I really just want to continue it. So I'll filter a question about lawyering through what you all have just been doing. Did Marshall ever, we've heard sort of one story from Professor Tushnet, but did Marshall ever talk about his NAACP work when you all were clerking? And were there any stories or just the manner of telling the story or anything that sort of stuck out in your memory?
The thing that stuck out for me, Marshall had first time we went to his house for a barbecue. And in his basement, he had in his basement on the wall bound volumes of the briefs he had submitted in appellate decisions, the Supreme Court. And we'd just been working for him for a little bit, but just to make conversation, I asked him, what case of these makes you the proudest? What was the one of which you're the most proud? And I thought, of course, he was going to say Brown versus Board of Education. He did not. He said of the Supreme Court cases, the one that made him the most proud was Smith versus Allwright, 1944, striking down the white primary. And then he said, actually, though he's best known as an appellate lawyer, that sort of lawyering was not he was not at his best as an appellate lawyer. He didn't think. He thought that he was at his best as a trial lawyer, speaking to juries. He thought that was his best use as a lawyer.
Can I just follow up on that? One of the things that really moved me and interested me and set my life course from clerking with Justice Marshall was the death penalty. I had never really thought much about the death penalty before I clerked for Justice Marshall, but that was a big deal in his chambers. And the first day on the job, the outgoing clerks gave us these two giant bound black loose leaf volumes, and they said, these are all the court's death penalty opinions. You better learn this stuff because the boss cares about it a lot. That's what we all call it. Did you guys call him the boss too? Boss cares about it a lot. And so that was my education in death penalty law, and it became a lifelong interest for me. But I paid particular attention when Marshall would tell stories about early in his career. He represented defendants at trial as well as on appeal in death penalty cases. Mostly they were black men accused of crimes against white victims in the South. And one thing he said often is he always knew when he had an innocent client, because that's when the jury would sentence them to life imprisonment instead of death. And that line really stuck in my head.
So let's continue to talk about Marshall as a Supreme Court justice. And as we move into this conversation, one thing I'll note is that he was such a tremendous lawyer that I do think his career on the court is sometimes underrated. And so what I'd like for you to do is to talk about what you think is his most significant single case or set of cases as a Supreme Court justice. And also, while you're answering that question, maybe you can talk about how Marshall interpreted the Constitution.
In 1983-84, at the very beginning of the term, Marshall brought 4 clerks together and made it very clear that he had something on his agenda for the year. And the thing that he had on his agenda for our year was attacking the peremptory challenge. So he told us at the beginning of the year that every case that presented any issue touching the peremptory challenge, there was in 1965, the Supreme
Explain
Court,
what that is.
in 1965, the Supreme Court of the United States, in a case called Swain versus Alabama, said that it was not a violation of the federal Constitution for prosecutors to take race into account in deploying their peremptory challenges. So when a jury is drawn, by law in every state, the lawyers, both for the state and for the defense, get a certain number of peremptory challenges in which they can strike somebody from a jury for any reason. You don't have to, and you don't have to say what reason. You just strike them. Well, in certain sorts of cases, particularly death penalty cases, there would be these jurisdictions in which there were no black people for year after year after year after year, because let's suppose you had a jury panel, the prosecutor would just strike all the black people. So in any event, and by the way, and the Supreme Court in 1965 said no violation. Well, this really got under Marshall's skin. He called us together and said, every case, anytime this issue presents itself, I want you to bring it to my attention. And over the course of the year, that's exactly what happened. And little by little, he was working as a lawyer, because what he did was he kept writing these dissents from denial of certiorari. And so the Supreme Court would deny the case, he would dissent, but he would also, along with the dissent, give reasons why he was dissenting. And basically what he was doing was telling the bar out there, I'm concerned about this, so keep bringing cases. And cases that kept coming up, and as he dissented and would write these fairly elaborate, briefs basically, he started getting other justices involved. And so finally, there came a point at which he wrote a dissent, and then there were 2 or 3 other justices who said, well, we think there's a problem here. We're not ready to, we're not ready to revisit Swain versus Alabama, but we do think there's a problem. And then a few more months go by, and on the Second Circuit, Judge Newman sort of broke, and he said, now I know that there's precedent over here that says that Swain versus Alabama is still good law, but you got all these justices who were indicating that they're concerned about this. And so he sort of said, I think Swain is no longer good law, or it's at least questionable. To make a long story short, there was a division within the United States Court of Appeals, and to heal that division, to resolve that division, the Supreme Court had to step in. And the next year, Batson versus Kentucky was decided, which overruled Swain versus Alabama. And just one more thing, and again, it seems to me this is characteristic of Marshall. When the Supreme Court of the United States in Batson versus Kentucky said that you could no longer take race into account in deploying peremptory challenges, Marshall concurred. And he says this did not go far enough, because what's going to happen is prosecutors are going to start lying. And so he basically said we should just we should figure out some sort of way that to make this effective. I don't think that even with this reform is not going to be effective enough. But he was acting on the bench as a lawyer, and it seemed to me he prosecuted that campaign in the way that he had done as a lawyer, and was very effective.
Others, Martha?
Well, one of the interesting things about Justice Marshall is that people find out that you've clerked for him, and they say, oh, you know, he was so significant. And you think, well, it must be, why do you know that? You're a tax lawyer. Well, it turns out he's a major figure in tax law, partly because the Chief Justice wouldn't give him other cases to write the opinions, but also he was a really technical, excellent lawyer. So in tax law, another one, First Amendment, free speech, certainly criminal procedure. So many areas where many people don't associate his name, he ended up having a big influence, and you know, civil procedure as well. You know, I've been thinking a lot about his dissents. By the time I clerked for him, he was in dissent more often than not. You know, his first year on the court, he dissented once. By the time he retired, he was dissenting probably in a majority of the cases, because the membership of the court had changed and the country had changed. And his dissents also are very striking, because very typically he would be writing alone, and there would be his voice much more unadulterated. He wrote dissents in which he would describe in great detail the actual lives of people, and that was really different than what other justices do. And he would describe what it's like to be poor, and why actually this amount of money being set for a bankruptcy filing fee would actually make it very difficult for someone. And he would write about prisoners and children and older people and students, members of religious minorities, immigrants, non-citizens, fathers, women, anyone who needed an abortion, rock music fans, people with long hair, and in each case, paint a vivid picture about their life. Another case in which, again, the vivid picture mattered, dealt with the question of whether someone on a bus who's being approached by a police officer had a choice to not respond to the questions. And the majority of the court said, well, you know, he's not being arrested, he has a choice. And again, Marshall paints in vivid detail, you're on a bus, there are these police, you can't leave. So I think in many ways he brought humanity to the court, but a rigor on facts, a rigor on context, a rigor on historical context, refuting the temptation of the majority to whitewash it and to go abstract and be formal and say, this is formal equality, what are you talking about? So I think while these are not famous opinions, these are not opinions where they changed the law, they changed what law could be.
I'd like to throw a discordant note in. I revere Thurgood Marshall. I really do. And in revere, I use that word advisedly. But Marshall, like anybody else, confronted dilemmas. He was a tough guy, and he went his own way. And I think that as time goes on, people, if they really want to really get down with Thurgood Marshall, they're going to have to get down with some things about him that I think will prompt people to be critical of him. So let me mention a couple. During World War II, there was a man by the name of Winifred Lynn, New York City. He gets his draft notice. Winifred Lynn goes down and he says to the authorities, "I am perfectly prepared to put on the uniform of the United States, but I'm a black man and I am not prepared to serve in a Jim Crow army. You want to send me to fight Hitler's Germany, but, racist regime over there. We got a racist regime here. I'll fight, but I won't fight in a Jim Crow army." He was prosecuted for draft evasion. He appealed to Thurgood Marshall for representation. Marshall said no. This man then appealed to the ACLU, Roger Baldwin of the ACLU. And Baldwin calls Marshall up to ask Marshall's opinion of what he should do. Marshall urged Baldwin not to represent Winifred Lynn. And Winifred Lynn's brother, good, strong, left-wing lawyer Conrad Lynn, has written about this, and has a very, and has a very jaundiced view of Marshall. Question: what is one thing? What was going on there? My own speculation is that Marshall, with respect to this sort of thing, I bet his view was, in time of war, this is simply not the sort of issue that one, pushes. Another thing about World War II that I've been interested in for a long time, certainly one of the most racist policies pursued by the United States government in the 20th century was the curfew imposed and the detention of people of Japanese ancestry. If you take a look at those cases, if you take a look at Korematsu, if you take a look at Indo, if you take a look at the others, a lot of organizations participated in those cases. One does not see amicus curiae briefs from the NAACP. I'd be interested in knowing what's the story there. Was Marshall asked? Maybe not, but sometimes you don't have to be asked. What was his thinking there? I'd be curious to know. One last thing, and this does go to Marshall's role as a justice. Someone mentioned early on about Marshall in popular culture. There was the one-man show with marvelous actor.
Fishburne.
Yeah, Larry Fishburne. Larry Fishburne had Marshall down to a T. Yeah. It's wonderful. There was one thing about that show, though, that struck me and I thought was sort of interesting, and I think there's a story behind it, but I don't know what the story is. I think it should be pursued. In this one-man show, the one-man show had Thurgood Marshall telling stories. The show had Marshall, the top said, Howard Law School. Marshall was telling the story. He went to Howard Law School. He was an alumnus of Howard Law School. He graduated #1 in his class at Howard Law School. Was very proud of that. Marshall, as a justice, or as a judge for that matter, never had a law clerk from Howard Law School. Marshall had more black law clerks than most of the other justices, but very, very few. In his first 12 years as a justice, he had one black law clerk. I think there's a story there. I'm not, on the question of being critical or not, I'm not sure yet. I'd like to know more about all of that. But those aspects of Marshall's career, those aspects of the decisions he made, it seems to me, warrant more attention than they have thus far gotten.
Can I?
Yeah, sure.
So Professor Minner mentioned the bankruptcy case, and that came up my term, and I just want to tell you a little about it. So the case involved a requirement that in order to file for bankruptcy, you had to pay $50. And you could pay that in installments. So the majority, through Justice Blackmun, held that, well, if you look at the amount the installments are, it's not that much. It turns out to be something like $1.48 a week. And you know, you should be able to, people should be able to accumulate that and pay it on a weekly basis. The judge was very upset about this outcome. Justice Stewart, or either Justice Brennan may have assigned the opinion to Justice Stewart, who wrote the line that sort of naturally occurs for the dissent. The court holds that some people can be too poor to go bankrupt. But Marshall, who would ordinarily just sign on to the dissent, was so annoyed, angry, that he wanted an opinion written, a separate dissent written. And in the opinion, I'll read you the part that I think Professor Minow was referring to. So it says, it may be easy for some people to think that weekly savings of less than $2 are no burden, but no one who has had close contact with poor people can fail to understand how close to the margin of survival many of them are. A sudden illness, for example, may destroy whatever savings they may have accumulated, and by eliminating a sense of security may destroy the incentive to save for the future. A pack or two of cigarettes may be for them not a routine purchase, but a luxury indulged in only rarely. The desperately poor almost never go to see a movie, which the majority seems to believe is an almost weekly activity. Okay, so that's, you know, I just want to note that when the opinion went into his office, the draft opinion went into his office, started out, I read it, it may be easy for some people to think. It actually started out by saying it may be easy for justices with life tenure and a guarantee of salary to think that weekly savings. He thought that went a little too far, so he took that out.
This is U.S. versus Crass, right?
But yeah, yeah.
Okay.
So I want to disagree with my friend and colleague, Randy, on some of the themes he raised. Not on the facts, but on the framing. So I, too, am a deep admirer of Marshall. I think it's asking too much to expect somebody to have exhibited virtue on every front. He was courageous, not just in the sense we use in talking about the law, but physically courageous to a degree it's hard now to imagine. He was stubborn. He persisted in a lifelong quest, much of which he accomplished. And on each of the axes you mentioned, he was far ahead of everyone else. So let's just take the clerkship issue for a moment. Yeah, maybe he could have hired more black law clerks, but he hired quite a few. And he also hired more women law clerks than anyone else. So when his colleague, Marshall's chambers were right next to Brennan's chambers. And they were good friends, and partly as a result, the clerks were good friends. And so you'd shuttle back and forth and talk with them all the time. There was a sense of common enterprise between the two chambers. Yeah, all the clerks in Brennan's chambers were white men. And that's not an accident. Brennan was uncomfortable with women. So Marshall was out front in many dimensions, and that includes hiring law clerks. With respect to not representing a complicated, conscientious objector in World War II. He was strategic in his litigation practices. He figured out what sequence was likely to lead to an outcome. Most apparent in the sequence of cases brought involving desegregation. He didn't jump for Brown first. It was a chain. And my guess as to the motivation behind that call is he thought this was the wrong first step. And something that I respect. Now, let me say one last thing about him as a justice. It's true, as some of you suggested early on, that his career as a lawyer looms larger now, and probably should. One of the reasons for that is because, as has also been remarked, he was increasingly in the dissent in his career. He just didn't have the position to advance as effectively a vision as one would have hoped. But there is a legacy of his dissents, different from the analogous legacy of Holmes, who was Oliver Wendell Holmes Jr., who was similarly in dissent on many issues. And one manifestation of that legacy is a method of constitutional interpretation that was, at the time, very unusual. Now, this being Marshall, he didn't announce, here's my method for constitutional interpretation. He wouldn't do that. But there was, in his judging, a method that is worth pointing out and celebrating. So at a time when other justices would focus on original intent, or would purport to focus on original intent, neutral principles, evolving consensus of values, he had no patience with any of that. His view of adjudication in general and constitutional adjudication in particular was you have a vision of justice, and that's not just anti-discrimination. It's also the importance of ensuring every person has a job, a home, an adequate standard of living, and freedom to engage in personal relations, marriage, sexual relations, and so forth. This is a generous version, a really generous version of a liberal vision. And he took on issues in light of how they conform to that vision. And I came to believe while working for him, and still believe, that that's a more honest and respectable stance in constitutional adjudication than the often fictional alternative approaches.
Thank you so much for that, Terry. I want to allow some time for a student question, if there is one in the audience.
Probably time for just one.
Yes.
Hi, my name is Leighton Watson. I'm a Grand Rapids, Michigan. I went to Howard Law School, so I always had a connection there with Thurgood Marshall. We also heard a lot about Thurgood Marshall. I actually, every day I wake up and I read one of his letters. I have a book of letters that he wrote to multiple people. So I read one of those each day. One of the letters, it discussed him having an opportunity to go into politics. Charles Hamilton Houston, his mentor, at law school, also first black, I think he was the first black individual on Harvard's law review.
Correct.
Charles Hamilton Houston had encouraged him to potentially go into politics. Yeah, it was interesting. And so he had a chance to in Baltimore, but then chose not to, apparently. And so I wondered, clearly his view as an advocate was through the legal system, as a legal advocate is the best way to achieve the ends that he wanted to achieve. Do you all believe that now, in the context, all the different issues that we see, a lot of the same issues that he worked on, do you believe that that sort of advocacy through the legal system is still the most effective way, or that he would agree that's the most effective way within the context that we see now and the challenges that the 21st century kind of legal system faces?
Thank you.
I have a couple thoughts about that. One is he was not a good student in college, and he went to a lot of parties, and he had a job at Howard Law School working in the library, and Houston, the dean, took an interest in him and also whipped him into shape, according to the justice. And that converted him to a disciplined life, with law very much being part of that. I think that he understood that the political system was rigged. And until the rules were fair, I don't think he thought politics, I mean, the primaries, the whole deal. And he didn't mince words, and that's how he talked about it. I think that today, the courts are one tool, but they're very limited for mass social change, for really redistributing resources, for changing hearts and minds. It's one tool. I think that very much in the spirit of Terry Fisher's comments, I think Thurgood Marshall was very pragmatic. He was strategic, but he was very pragmatic. And he would use the tools that would work. He'd use social science if that worked. He'd use experts if that worked. He'd use media if that worked. And I think that that's the advice that I learned from him, and I would recommend, along with his advice, choose your battles. That was his advice, and I think about that every day.
Well, I think we probably should end here. Thank you so much, professors, for your comments. This has been lovely. Thank you.